Would everyone please take a seat, please? Thank you very much. Just before we go on to the Q&A session, it was suggested to me by the expert advisory group that it would be no harm if I read into this ballot what I stated in relation to ballot 2, because it also applies in relation to ballot 3, and this is just to remind you. It is important to note that voting for either option 1 or option 2 in draft ballot 3 may result in an outcome that allows for the liberalisation of the current legal regulation of termination of pregnancies, or alternatively an outcome which results in the rights of the unborn being given greater protection. This is because both legislation enacted in consequence of a repeal or in consequence in option 1 of the Constitution allowing the Oireachtas to legislate, giving it free rein in relation to legislation, or, and again, I'm going to emphasise, depending on its terms, a provision replacing or amending an Article 40.3.3 in the Constitution could have either effect. So in either scenario, the outcome could be either, depending on the legislation or the amendment made, the outcome could be either liberalisation or greater protection for the unborn. So just to remind you of that. Now we'll start with the questions.
How are you doing? Dave, table 6. In relation to option 2, if it was selected, could you just clarify maybe how the lawmaking powers of the Oireachtas would be limited? So it says, like, you know, the actual wording or the introduction to it says, as interpreted by the courts. But could you specify exactly how that would work, how it's limited? Yes.
Okay, so I'll take that question. So if option 2 is selected, which indicates that there will be a new constitutional provision addressing the issue, so the question is, how would the power of the Oireachtas be limited in that context? So I suppose this depends on how you decide to vote in ballot 4C, and the extent to which the Oireachtas adopts those recommendations, and the extent to which that's subsequently passed by a referendum of the people. So you're given various options in ballot 4C to indicate your preference. So for example, if the Assembly were to vote in favour of option 2, as you've suggested, and later in favour of recommending, for example, to look at one of the examples on 4C, if you voted in favour of recommending that termination of pregnancy should be allowed in cases where there's a serious risk to the health of the woman, then if this was subsequently put to the people in a referendum and passed by the people in a referendum, then the Oireachtas would be constrained by that, and they couldn't pass legislation contrary to that new constitutional provision. Does that answer your question?
Yes, table 1.
No, it's up here.
Oh, sorry.
Yeah, because there's no mic there yet.
There's a mic over here on table 4.
Good afternoon, Thionól from table 4. Just first of all, on behalf of my table, we'd like to make a proposal that the ballot paper is amended to say option 1 would be Article 43.3 should be replaced with a constitutional provision that explicitly authorises the Oireachtas to legislate to address termination of pregnancy, any rights of the unborn and any rights of the mother. Option 2 would be amended to say Article 43.3 should be replaced or amended with a new constitutional provision that directly addresses termination of pregnancy, any rights of the unborn and the rights of the mother. We feel that it's a bit worrying that the rights of the mother weren't included.
So you're taking out both?
Taking out both and including the rights of the mother.
Including the rights of the mother.
And then not representing my table, but representing myself, I just want to say that it is important to note that the options presented on this ballot funnel us into voting on abortion and the rights of the unborn only. Article 43.3 does not mention termination or abortion, And crucially, it does have effects outside of this area. This is disappointing.
Sorry, would you mind repeating that? I didn't quite get it.
It is important to note that the options presented in this ballot funnel us into voting on abortion and the rights of the unborn only. Article 43.3 does not mention termination of pregnancy or abortion, and crucially, it does have effects outside of this area. This is a disappointment. I just want this on the record.
Oh, yes.
Thank you.
Yes, I understand what you're saying, yeah.
So, what do you want to say about the...
Yeah, yes, we'll deal with that suggested variation. Yeah.
What do you think?
I see no problem with it. Difficulty in terms of how it would affect other votes. So I have no difficulty with it being put to the floor. Yeah. Well, presumably there's logistical difficulties, but that's not a reason not to change it at all.
Yeah,
Absolutely not.
yeah.
I don't know.
Put it to a vote?
Yeah. I mean,
The citizens?
yeah.
Yeah,
I mean,
yeah.
I think probably the thing to do is, if that's a recommendation, I suppose it's conceivable that there are other proposed amendments.
Yeah.
So
We-
maybe
we'll-
we'll hold off on voting on
Yeah.
any amendments to
Yeah.
the wording until the
Yeah.
end of the session.
And I just have one question, and that is whether and any rights of the woman would be more appropriate than the mother, because of the terminology in the 2013 Act and all of that.
Sorry, we took mother from the original article 40.3.3.
All right, but you don't have any object?
No.
Yeah, all right, yeah, very good. Well, we'll come back to that, and don't let me forget it, please. Yeah.
10, table 10.
Yes, table.
Good afternoon.
table
Just
seven.
a small question regarding option 2. In the case of Article 40.3.3 being replaced with a constitutional provision that addresses the rights of the unborn, who would be the author or authors of that provision? And would they be expected to fully consider the recommendations and findings of the Citizens' Assembly also in drafting that provision?
So I suggested in the first instance this would be a recommendation in your report, which then goes to the Oireachtas Committee, as I understand it. So the first question would be where it would go from there. But if it got to the stage of drafting, then my understanding is that drafting would be done through the departments and facilities in government that are responsible for drafting constitutional referenda. So what you would be giving in your for ballot would be an indication as to the reasons and circumstances in which you think the Constitution should be amended in the various ways, but it would then be, as a matter of drawing up wording for a proposed referendum, a matter for the drafters attached to working with the Oireachtas Committee and government generally. I don't know if the chair has any other thoughts on that.
No. I mean that is the case. I mean we're putting this in very general terms, but we look at it in more depth in ballot 4, whichever ballot 4 we go to. Yes.
Thank you, Judge. I'm the facilitator for Table 1, and we have, the citizens at this table, beg your pardon, have 2 questions for the panel. First question is, if option 1 is carried, does this create an explicit mandate for the Oireachtas to create legislation, and if so, is there an explicit time frame between passing a referendum and devising the legislation? And the second question is, if option 2 is carried, does this mean that the specific reasons for termination would go into the Constitution? Thank you, Judge.
Okay, so I'll take those questions. But first of all, obviously what comes out of here is recommendations to the Oireachtas for the Oireachtas to consider. Okay, but if we take the question as if option 1 is carried, in terms of if there were to be a referendum carried in terms of option 1, that wouldn't create any obligation on the Oireachtas to create new legislation. The existing legislation, the 2013 Act, would continue in force, but the Oireachtas would be free to change that legislation at any time it wanted, in any way that it wanted, because the Oireachtas would have full power to regulate issues around termination of pregnancy and so on. And I think it follows on from that there's no question of a time frame between the referendum and having to pass legislation. In response to question 2, is if option 2 is carried again, does this mean that the specific reasons for termination go into the Constitution? Yes. Answer.
Hi, Jordan from Table 14. I just wanted to ask a question, a clarification, I suppose, on the wording of option 1 and 2. Clarification regarding the distinction between the term termination of pregnancy versus the word abortion. Because on a number of occasions the Assembly received information from both advocates and professionals drawing distinctions between either phrase. Most memorably, Dr. Angelo Levitino, a staunch anti-abortion advocate, said that he had no issue with termination of pregnancy because the unborn might survive outside of the womb. I suppose termination of pregnancy also allows for the 2013 Protection of Life During Pregnancy Act to, it's not unconstitutional because it's a termination of pregnancy and not an abortion. So I was wondering, could there be some, I suppose, legal clarification on the difference between the two words, or medical clarification or input? Thanks.
Thanks very much. I'll take that question for you. I suppose just to give you a sense of where we arrived at the choice of terminology for the draft wording, we were influenced by the fact that the 2013 Act uses the phrase termination of pregnancy, and also in consultation with our medical colleagues on the panel, that in medical practice the word abortion is generally not used. In terms of your question about the constitutionality of the 2013 Act, I suppose it's important to note that neither the 2013 Act itself on its face, nor the case on which it's based, the X case, expressly deals with the issue of gestational limits. So it's not to say that there isn't the possibility that those might be implicit, but that it's never been expressly dealt with, either on the face of the legislation or in the case. But as you'll see when you move on to looking at the next draft ballots, there is scope for differentiation in terms of gestational limits on the different grounds that are being put to you. So I think we definitely see the point that's being made about the potential for confusion in terms of the use of terminology. So what I'd be suggesting, if it was something that would be satisfactory for that table and anyone else in the room who shares the view, would be that we on the group would have a look at that wording overnight, and before we would come to ballot 4, be able to come back to you with some discussion on whether that wording works appropriately or not. For the purposes of ballot 3, we're using the word termination of pregnancies, that phrase, in quite general terms to cover the issue more broadly. So I don't think it's of crucial importance at this stage, but certainly I think we do need to look at it before stage 4. I think it's an important point that's been raised. Does that address the issue?
Yes.
Liz, do you want to add anything on that? No.
Judge, I'm the facilitator for Table 7, and I have 2 questions from 2 of the members at the table. First one is, if option 1 is chosen by the majority, would this mean Article 40.3.3 could be taken out of the Constitution? And the second question is, in option 1, it states addresses termination. Does this mean that the Oireachtas could choose to retain the status quo and not liberalise it any further?
Could you just repeat the first part of the question, please?
The first question and the second question.
First question.
If option 1 is chosen by the majority, would this mean Article 40.3.3 could be taken out of the Constitution?
So the answer is yes. Okay, so what option 1 does is to propose the replacement of Article 40.3.3 with an entirely new constitutional provision. So the current text comes out and a new provision goes in, to the effect, as you see there set out in the ballot, that the Oireachtas is expressly authorised to legislate to address termination of pregnancy and rights of the unborn, and subject to a possible amendment that's being proposed the rights of the woman as well. Okay, so you would have heard and remember probably from Brian Murray's paper and presentation that canvassed as one of the options that could be used to address some of the uncertainties around the consequences of repeal. That one way around that would be to insert this kind of provision expressly into the Constitution. But yes, the short answer is this would result in 40.3.3 as is coming out of the Constitution.
And I'll answer your second question, which was looking at the word addresses in ballot 1. So in option 1, sorry. So in option 1 where it says it authorises the Oireachtas to legislate to address termination of pregnancy and any rights of the unborn. I think your question was, does this mean the Oireachtas could choose to retain the status quo and not to liberalise it any further? And the answer is yes, because you're giving the Oireachtas the power. So they could either retain the status quo as is in, for example, the 2013 Act, or they could change the status quo by changing the 2013 Act or repealing the 2013 Act. The Oireachtas may be guided by or influenced by the recommendations that you make in answers to question 4B, but that would be a matter to go into your final report and the extent to which the Oireachtas would be influenced by those recommendations in drawing up any subsequent legislation.
I am the facilitator for Table 5, and there's two questions here from the table. The first one is, can a referendum ballot paper have numerous options in relation to one topic? The second question and point for clarification will be asked by a member, by a citizen from the table, but I would like to state that during the roundtable discussions there was mixed views expressed.
There was a what?
There was mixed views expressed by
sorry.
all the members, but one member would like to ask a question and just get some clarification.
Well, let's perhaps deal with the first question first about the content of a referendum.
So just to clarify what you're asking, it's the position that you could have a number of distinct issues on one ballot paper, but not a breakdown of multiple options within one issue, if that makes sense to you. Does that answer your question?
Yeah, that's what they're...
Hello there, I'm a citizen from Table 5. A comment on option 2 and a query on option 1. Now, most of the people here at the table agree that option 2 is fine as it is, as it provides an option for those of us who wish to retain Article 433 in the Constitution and retain it somewhat, or to provide small changes in a few circumstances while still giving rights to the unborn. So we have no problem with option 2. However, some of us have a query on option 1, is that what we should be recommending is a constitutional change, should be very straightforward in its wording, and that it should be formed to give total power to the Oireachtas to legislate in all circumstances on the matter of terminations. Now, some of us fear that putting in too much wording will bring us back to 433 or maybe back to option 2. So the question is it necessary to have in option 1 to have the words "and any rights to the unborn" included in this option? Now, so I'm just asking, why were they put in? So as to differentiate it from option 2, why were these words put in? Should these words be retained? Why should they be retained? And if the Assembly so wishes, can they be removed? Okay.
I'll answer your question. I think the first thing to say is that the wording refers to any rights of the unborn. Okay, so our reasoning behind using the word "any" in that space as opposed to the words "the rights of the unborn" was to capture the fact that you're alluding to, which is that legislative change coming on from that might be to the effect that there would be no rights for the unborn, and that might be the intention of citizens in voting for such a provision. So the use of the word "any" was intended to capture the fact that you're not presupposing that those rights are there, and you go on in ballot 4 to be able to indicate through your choices in ballot 4 whether you think those rights should be there at all or in any circumstances. So that was the reasoning behind having the use of the word any, and certainly our, as the judge alluded to, option 1 can capture legislation, can capture giving authority to the Oireachtas, resulting in legislation that would either liberalise or restrict the current abortion regime, but it is a conferral of authority on the Oireachtas to deal with those issues.
So can I make a recommendation that we just and put it to the Assembly that we drop the wording "and any rights to the unborn" from option 1? Is that possible?
Yeah. Is that a matter we should adjourn to consider?
Yeah.
The other one, the mother in.
I would suggest that probably it's related. We need to consider the two proposed amendments in conjunction, because I think they may, in terms of how they'd be best given effect, to be linked. So it might be appropriate to consider those together.
Yeah. Well, maybe we'll, as they say in the courts, rise for a minute or two. In fact, it'd be a little bit perhaps longer than a minute or two. But we'll take the questions, but we'll take all the questions and then we'll rise and we'll discuss it. We'll see. And we'll discuss both of those, yeah. Any other question?
Hi, I'm the facilitator here for Table 10, and I've been asked to ask the following question. If the majority vote is for option 2 with a new constitutional provision that directly addresses both termination of pregnancy and any rights of the unborn with reference to the ballot of 4C Part 2, are the recommendations 1 and 2 not at odds with each other?
Say that again.
Are the recommendations 1 and 2 not at odds with each other?
This Roman 1 and Roman 2?
No.
No.
So can I just confirm, do you mean the recommendations from ballot 1 and ballot 2? Is that what you mean?
No, part 2 of ballot 4C is what I think he's talking about.
It's ballot 4C Part 2.
Yeah, oh yeah. And you think there's an inconsistency between those two? Is that your point?
So I can address this question, I think. The question really then is, what's the difference between 1 and 2 within Part 2 of Ballot 4C? What it does is, the reason it has been structured like that is to allow the Citizens' Assembly in Ballot 4, if it wishes, to empower the Oireachtas more in some areas than others. So there's 8 things at present that you will be asked to vote on in whichever of the ballot 4s we get to, but let's assume it's ballot 4C for present purposes. And it may be that in some of those, citizens want to retain clear provisions in the Constitution and put quite a bit of detail in the Constitution, while it may also, but in respect of others, that they might want to give more scope to the Oireachtas to make the rules. Okay, so it's a good point to raise now, because it is then obviously relevant to your choice in ballot 3 as to whether you choose between option 1 and option 2. In choosing option 2, you would be allowing yourself in ballot 4C the possibility on some issues to make a very clear statement in the Constitution, and on other issues to give more power to the Oireachtas.
To legislate.
To legislate.
Yeah. Does that answer your question? Yeah, thank you. Anybody, any other question?
I'm facilitator for Table 11. A citizen at this table has asked me to ask the following question. Which option is more likely to result in a more liberalised situation than currently exists?
That's a matter of policy, isn't it really? What?
I think we can answer it, although it may not be a satisfactory answer. In principle, they are all equally open to either approach, and beyond that, it's a matter for your own political judgment as to which you think is more likely to happen to give the result that you want to give, and obviously different members will have different views on that.
Any other questions? All right. How long do you think we would require? 10 minutes. All right. We will sit again here at 4:10. And we consider those two questions.